let me just start by saying that the purpose of this session is all of you have basically questions about H-1Bs. That is what we will go over today. We will go over some topics and questions surrounding people who are interested in applying for H-1Bs or have applied for H-1Bs and have specific questions about that. Okay. My name is Dhenu Maru. I am an attorney at immigration law firm SwagatUSA. And one of the main application types we do work on is H-1Bs. We also do family-based immigration and all other kinds of visas as well. And I'll go over actually some of them in the session today. I'll just wait for like a couple minutes to see if anybody is joining us. Zell, you will be in charge of making sure that anyone who's interested in getting into the meeting is able to get into the meeting, okay?
Okay.
All right, so everyone except for me and Zell are muted for now. We will unmute when there is time for questions towards the end, okay? In the meantime, you can write those questions in by chat. Zell will basically be able to read them off as soon as I'm done with the basics. And then we can go into the specific questions. So to start with, let me ask if you can, type the number 1 if you understand the basics of H-1B or know what H-1B generally is. Does everybody see where you access the chat? Just type in number 1 if you, okay. So some people really do know the basics of H-1B. Very, very short, since I probably don't have to explain it in detail to everyone. Very, very short, the basics of H-1B. It is an employer-employee visa. It is applied for by the employer. That's something very unique to the American immigration system, is that it's the employer who initiates this application. You cannot apply for your H-1B yourself, right? So first you have to find a place to work, and the employer has to file your application. There are certain main requirements or components of the H-1B. One of them is that it is the job for which you apply has to be a specialty occupation. What that means is that it has to be a job for which at least a bachelor's degree in a specific field is required. Now, we'll go over how USCIS interprets specific fields, but basically what we've found is that their interpretation has become more and more strict. So in the past, specific fields might have been more loosely interpreted. These days, they have started becoming more and more strict with how they interpret specific, specialized occupation and the specific fields. The other thing that's important in the H-1B, it is for employees, so no independent contractors can apply for an H-1B. Another thing that's also, and a true employer-employee relationship has to be proven. It's one of the tenets of the application process. So when somebody's working at a third-party site, for example, you'll see that there are more requests for evidences issued on that particular topic. Does the employer who's filing for you truly have an employer-employee relationship with you? In other words, do they control your time? Do they control your activities the way an employer does? Or are they simply a connector between you and the place you're working? So that's one other requirement. Another requirement that many of you are probably familiar with is the prevailing wage requirement. Prevailing wage basically means that the employer has to ensure that you will be paid what is the prevailing wage based on the Department of Labor statistics for each and every field. So one of the first parts of applying is filing an application for a labor conditions application, an LCA, with the Department of Labor. That is where you attest, that you will be making a certain a certain salary, and that salary is above what the minimum requirement or the average or the prevailing wage for a specific field is. Okay, so those are the bare bones basic. Now, the other thing is that H-1B does have a cap. Usually, if you're working with a private employer, there's a cap. And the cap basically means that there are, 65,000 general H-1Bs issued to people with bachelor's degrees or more, and additional 20,000 H-1Bs for people who have master's degree. Every year we get many, many more than 85,000 applicants, which means that, what the USCIS has essentially done is run a lottery. And now some of you are familiar because you may or may not have been picked in the lottery. And that lottery period actually just passed. So this year, the government has done something a little different. They have done the lottery in advance of when people filed the application for H-1B. In the past, it was always you file the application for the H-1B together and, all together, and then the lottery was done after that. So this year, we have seen that the government has switched everything up a little bit. The lottery was done in March, and the H-1B period of filing has, they've given us a 60-day window to file the applications, which is a little bit more than what they have, considerably more than what it was in the past. In the past, everybody had to try and get it into the system in the first week of April so that they could be considered in the lottery at all. So that's what's different this year than in the past. Now, other things that you will see this year, there are a number of questions that I have gotten from clients, prospective clients who have called our office, who've asked these questions. Questions like, I got selected in the lottery, but because of this COVID situation, I don't know if I'm going to have a job. Am I okay to change the job? Is it fine? Can I get a different employer to pick me? The answer is unfortunately no. Your employer does have to file an application for you. They have promised to do that as a part of participating in the lottery. But once they have filed the application for you, you will have more leeway to change your position afterwards. So you want to make sure that they do file the application for you based on the lottery pick initially, because they have, that is part of the agreement of the lottery. Okay, now I'm going to address some of the questions you guys have sent to us in your forms. And there are questions, some of them are very specific, some of them I might have answered with a more general overview. So basically, there are questions that people have around extensions. Like some of you might have heard 240-day rule. What does that mean? 240-day rule is only for people who are applying for extensions for their existing H-1B with the same employer. And they have 240 days automatic extension applied while their application for extension is pending. That does not apply for transfers. It does not apply for change of employer, or it doesn't apply for consular processing. It's for people who are in the United States with an employer and they're extending their status. Some people are asking, how many years can I stay in the US with this visa? That's a good question. It's usually given for 3 years at a time, but a maximum of 6 years. So within that 6-year period of time, your employer has to either file for your green card application, or you have to depart the country or change it to a different status other than H or L. If you depart the country for a period of 1 year, then you come back, you reapply through the lottery, you get a reset of the 6 years. Or you change your status to a different status altogether. And I'll talk about one of those different statuses, actually. And this is very relevant for people who have not been selected in the lottery. One of the statuses that I have started hearing a little bit about these days, but in the past it was definitely very underused, and that status is an O-1 visa. if you know what an O-1 visa is, please type the number 2 in the chat. Okay. Many people don't seem to know what the O-1 visa is because I don't see any responses. So O-1 visa is basically individuals with extraordinary ability visa. This visa is not appropriate for everybody who is eligible for an H-1b, because one of the things that you do have to prove is that you have to prove that you have extraordinary ability in a specific field. And it's not limited, but it is usually science, education, business, or athletics is for O-1. For motion picture or television industries, O-1b. So there's O-1a for these fields that I mentioned, and O-1b, and different types of O's as well. So O visas require something a little different, and they also have a completely different way that they are conducted. There's no lottery with O-1, there's no cap. So that is one of the reasons that it becomes a nice alternative for people who are not selected in the H-1 lottery who qualify. You have to show that your ability in your particular field is above normal, right? Like you have to show some kind of extraordinary ability. You have to show that you have a contract between the petitioner and the beneficiary. So this is not one of those visas that you self-file for. This is definitely one of those visas that your employer applies for you. And you have to show your itineraries, your activities, what you intend to do in the United States, if it's working at only one site, or if you're going to be traveling between locations, or if you're a performer, you're going to be performing. You have to show many details around that. You have to show proof basically that you are qualified and that you have extraordinary ability in that field. So if you have awards, if you have, if you're paid higher than normal, if you have recognition, if you've been published, those are examples of things that you can show that your ability in your field is above normal. You can also show recommendation letters often. So these are some. This is one of the alternatives to H-1b lottery visa. Another one which is appropriate for people is getting a Cap-Exempt H-1b. So a Cap-Exempt H-1b means that you're working at a nonprofit or an government institution that has connection with higher education in some cases, research organization. Those are some examples of H-1b Cap-Exempt organizations for which you can apply for. And that, again, because it's Cap-Exempt, there's no limitation. It means there's no lottery. You can apply for it at any time. Big examples of Cap-Exempt organizations oftentimes are hospitals or universities. Universities often have a research component to them. So those are some big examples of organizations or institutions that have a possibility for applying for H-1b Cap-Exempt options. Now, other than that, there are some countries who have additional options. Some countries have e-visas available. India does not. But I know Pakistan, for example, does have e-visa availability. Many European countries do have e-visa availability. That is another option for if you are in one of those countries or born in one of those countries that have e-visa eligibility. You can apply for an e-visa. There are two types of e-visas that are very common. One is an investor visa, and another one is like a treaty trader visa. So this is more for people who have kind of a interest in opening a business, something like that. There is, speaking of business, another visa which is oftentimes an alternative to the H visa, and that's the L visa. The L visa is actually very commonly used as an alternative. There are a number of ways to get an L visa. Two main ways, L1A and L1B, are the two types of L visas. And for an L1A, you have to be an executive or manager. And for an L1B, you just have to be a specialized employee. Now, L visas are considered to be transfer visas. What that means is that you're looking at the visa being structured as somebody who is in a foreign company and who is being transferred to the United States branch of that foreign company. So if you're working with a multinational company, then an L visa may be a possibility for them to be able to send you to the United States temporarily, okay? Another option that sometimes L visas are used for is for people who have their own individual businesses in their own country and they want to move to the United States and open up a branch to their business. There are many, many considerations that have to be done, taken into account. So if you're interested in L visas, definitely seek a specific consultation, because these are not easy visas to obtain. However, they do not have the lottery component. They're not limited numerically. So it is a good option to entertain if you are interested in either working in a company that is a multinational company and you have to be in the overseas office for at least 1 year, okay? So you have that. Or if you are looking at having a business that you have open in your home country and you want to move to the United States, open up a branch of that business or a subsidiary or an affiliate of that business in the United States. So that's another very common option to the O visas. I'm going to go into some other questions that I think we probably have had. All right. So at this time, if anybody has, questions about anything that I've talked about so far, the L's or the O's, feel free to type them into the chat. If one of these is resonating with you and you think you might want to learn more about it, that is something to, consider. Of course, for people who have for people who have STEM, OPT, you have multiple attempts at applying for your H-1B. You may always apply next year. You may always, you have an opportunity every year. If you're overseas, you can apply year after year. So that option is always there. Another option for some people that I've seen in the United States is people who go on F visas. And F visas, you have to pursue a field of study that is maybe tangential to what you have learned or in addition to what you've learned. And you have to make a case that that field of study is sincerely of importance to your career prospect. And that's because your F visa application will require proof of that. And then once you have your F visa, sometimes what people do is they go on CPT. Now, CPT and OPT are interesting terms. CPT means curricular practical training and OPT means optional practical training. The key term in both, I think, is training. And it's important that you understand that this is a training opportunity, which means that if you're in CPT, it's not really the same as just working in a job. You're in training. You're supposed to be working in a field that is connected with your education. You have to get permission from your educational institution to undertake CPT credits, and it's something that is given credit, that you get credit for. So CPT is a part of your education. It's curricular practical training. OPT is after you've graduated, and it is also training. So you still have to have supervision. You still have to have people who you can go to for training. You still have to have components of formal training as well as informal training, usually under the OPT as well. So those are some important points to note. But those are also options that I've seen a number of people take. when they don't get selected in the H-1B lottery. Now, H-1B lottery this year was unique, like I said. So there's actually a third yet another possibility. Because H-1B lottery this year was done in advance of applications, and right after the lottery, the COVID crisis hit. So what that means is that possibly there are lots of employers who are not going to be in the position to file H-1Bs, even though their employees have been selected in the lottery. So what they're doing this year is they're actually planning to return those lottery numbers for people who have not filed and award that opportunity to other people who are not selected in the first round. So, you know, June 30th is the last day that people have to file the application based on their current selection of the lottery. But then if they don't file by then, or if their filing is incomplete or denied, or, you know, there are some problems with it, then that number will go back into the pool, and there may be a second round of people who are selected after the 30th of June. You know, they may award lottery numbers randomly to people based on the number of people that actually go through with that application the first time. So it's a little different, and it's a little more opportunity for people to be considered after the first round. I wouldn't count on it. I would say you still should look for plan Bs, and plan Bs could be any of those plans that I mentioned before. And if you think you are, you know, candidate for an L or candidate for an O, or have questions about getting into an F1 program, then it's really important to talk to an attorney. Also, Cap-Exempt, don't forget Cap-Exempt, guys. Cap-Exempt are, you know, they're great opportunities. There's a lot of work that is available in the Cap-Exempt category as well. Okay, any questions so far? So I see that there's somebody who asked me a question. 240 days are expiring on May 10th, and my RFE response was filed today. What if I don't get the USCIS results before the 240 days? That's a really good question. So I'm assuming this person actually has an extension pending, because the 240 days only applies to extensions. So if the 240 days are running out, and RFE often causes delays in the application processing. So this individual got an RFE, and you know, they want to know how they can sustain their job. You have to stop working the day that your 240 days expire. As soon as premium processing is available again, you should apply for premium processing. So it's really important, actually, that you stop working when the 240 days expire, and whenever possible, you apply for premium processing. It's not available right now. They've stopped premium processing as a result of this COVID situation. But this may result in a gap in employment. However, you are allowed to stay in the United States while your application is processing, even past the 240 days. I hope that answers your question. I wish that there was something else that could be done, but unfortunately, that is the only option at this time for that 240 days. Now, keep up with the news, because AILA did request to the government for an extension of the 240 days. AILA has filed, I don't know if it's a formal lawsuit or if it's just a request, but they have definitely filed something with the USCIS to ask that, you know, extensions and expirations of RFE responses and things, those kinds of deadlines get extended as a result of this, you know, crisis situation that we're in. So keep up with the news, but as of now, that has not been the case. So, so another person has asked, as I'm currently on an H-1B visa and will file for a green card in the future, can I pursue full-time education after the approval of my green card education application? So you can, when you're a green card holder, you can do everything, right? But once your I-140, I'm assuming that by approval of green card application, you actually mean the approval of your I-140. The I-140 is not actually the complete green card application, but that is the employer portion of it. And so, yes, you're right to question whether or not full-time education, and by that, I'm assuming the reason you're asking is that, can you go on an F1 visa after your I-140 is approved? Is that the question that you mean to be asking? Okay, so an F1 visa is a non-immigrant intent visa, and that does bring a challenge. So if you're expecting to file an F1 visa for pursuing full-time education, then I don't think it's a good idea to file an I-140 in conjunction with that. There are ways to potentially make an argument that you have temporary intent in the short term while permanent intent in the long term, but it's a very tricky argument. So in the current immigration environment, it would be scrutinized too heavily. So I don't recommend that you file for that unless you're willing to take the chance. But if you can wait for the I-140, then I would say hold off on the I-140 if you're pursuing an F1. Okay, so let me go back into some of the questions that we got in our responses, unless somebody has another question that they asked for in the chat. Okay, so people are asking things like, how can I find an H-1B sponsor? I mean, it's like filing for any kind of employment. It is difficult in this time to find an H-1B sponsor because people are struggling. I mean, businesses are struggling financially, or they're at least nervous financially, and they're questioning, whether or not they can take on an additional employee, right? So it's a really good idea to apply for as many positions as you can from overseas. I'm assuming this individual is overseas, but maybe not. But it's a really good idea to apply for as many positions as you can. Really just, it's about finding the job, right? So once you find the job, if they need your qualifications, then absolutely they could sponsor you in a different year. They cannot sponsor you this year because this year the lottery is already completed. Another option that a lot of companies are doing is allowing for remote work while you're, overseas, and then, maybe a year later they built enough of a relationship with you to file in the following year for your H-1B. So that's another way to approach it. So this is a very COVID-related question that I want to go over. H-1B was approved with consular processing, but I'm unable to go to the visa stamping due to travel restriction and consulate closures. Need help on options to activate H-1B and begin work. This is a very time-related question because this is the kind of time where definitely there are closures for consulates, and it is difficult to go for an H-1B stamping appointment. Unfortunately, let's see. If you have been approved for an H-1B change of status, you may or may not need stamping. That's the first thing, right? So you really have to first check whether or not stamping is even a requirement. Sometimes stamping is just a document to enter the United States. Now, if you're somebody who's overseas and you don't have a visa appointment, there's no way for you to enter the United States to start employment here. You can probably start remote employment, and that's the best that you can do in that situation. But if you're here and you've been approved for a change of status, you may not need stamping to start employment with your employer under change of status. So, that's something to explore differently, okay? All right, so sometimes people are asking, like, what if their current status is expiring and they didn't get picked for the lottery, and they can't travel because there's all these travel restrictions here. That's absolutely correct. And another option that I've suggested to a number of people who called our office is, for temporary purposes, you may want to apply for a B2, just to change the status to a B2, just so that you don't go out of status. It's really important you don't go out of status. Okay. Okay, another person asked, is premium processing option still available for H-1B transfer? No, premium processing is available right now. But yes, in general, premium processing is available for H-1B transfer. You're just gonna have to wait until premium processing is even opened up. Okay, so that's the thing with this. Now, how is COVID-19 in general, impacting people? Some of the things we've discussed, right? Consulates are closed, premium processing is closed, certain offices are closed, so employers are having a difficult time. But then also, you have to understand that USCIS is actually still operating. So even though you're not able to take biometrics offices are closed, interviews are closed, but USCIS is still processing cases. So people oftentimes have, nervousness because they think, okay, is my case really going to be processed? Yes, your case is still being processed. USCIS is open, and they are working, and we are still filing cases. We're still filing cases because they're open and they're working. So yeah, that's the problem is for people who are trying to get appointments at the consulate, for people who are trying to get any kind of in-person assistance. That is closed for now. Okay. All right, let me see if I get, oh yeah, this is one I get very common. What if your H-1B is denied? How many days can you stay after a denial? And there is no official grace period that applies for a denied H-1B. So technically, there is 0 days that you can stay after an H-1B is denied. However, USCIS has taken a little bit of a practical approach with this, and they've said, you know what, if somebody leaves within a couple of weeks of their denial, that's not going to be a reason for us to revoke their future visas, because that amount of a lag time is reasonable. So it's a reasonableness test, okay? So I would say as soon as possible, you should leave. Now, in the future, if you ever have to come back and apply for DS-160 or any other form that asks you questions about whether or not you've ever had any overstay or you violated the terms of your non-immigrant visa, if you've overstayed, even if it's just a few days after the denial of an H-1B, you are going to have to answer yes to that question and explain. Okay, so it does have a consequence, and you do have to answer yes to it, and you do have to explain. Okay, now nobody asked me this question on this chat. However, these are questions that I sometimes get on private consultations with clients who are confidential. So I just want to, without having to have somebody ask me, I'm going to just address a few issues that I commonly hear. And one of them is an issue concerning crime, okay? If you are on any kind of a visa, whether it's an F1 or an H-1B, and you get charged with a crime, no matter how small that crime is, these days we're seeing people who are charged with, most of the shops are closed, so this has gone down. But we used to see people who were charged with small things like shoplifting. We used to see people who were charged with domestic battery. We used to see people who were charged with DUIs. DUIs is, if it's a first-time offense and you're not a repeated offender, it's usually okay in the sense that you can go to the consulate. You do have to tell the truth, always, about all of your criminal records. You always have to get a certified court disposition from the court, the county clerk, because that certified court disposition is going to be the only way that you can show the outcome and that you've completed whatever the penalty or punishment was for that crime, or if that crime was dismissed, then the outcome of that crime being dismissed. Okay, so you definitely have to bring that. Now, sometimes what people do is they get like a small crime, they get it expunged after a certain period of time. Expungement means, and I'm not a criminal defense lawyer by any means, but expungement means that, you know, it's kind of wiped out of your record, or that's how it's explained, right? So nothing gets wiped out of the record of USCIS and Homeland Security, okay? So even if your crime is ever expunged, it doesn't mean that it's wiped out of the record for Homeland Security. You still have to make sure that you have your certified court disposition. And the crazy thing about the system is that most criminal defense lawyers do not understand immigration law that well, that they know that. So really, you have to, if anything like that occurs, you have to seek the assistance of both a criminal defense attorney and an immigration attorney, always, okay? When you're not a citizen, every incident that you have always has an immigration consequence. There's always an immigration consequence. So whether it's a divorce, whether it's a crime, everything that you do could have an immigration consequence. You always want to check in with your immigration attorney before relying on advice for anyone, because the advice for a divorce lawyer may be correct for a citizen, but there may be a wrinkle when it comes to immigration, right? The advice for a criminal defense lawyer would be correct when it comes to citizens, but there may be an additional wrinkle when it comes to an immigrant. So you have to be careful about that. You always have to keep your immigration lawyer in the know with regards to changes in your life. Okay, that's one thing. And I get, surprisingly, I think people don't realize oftentimes how common these things are. So if you do get in one of these situations, there's nothing to be ashamed of. You really do have to be responsible though, and you do have to seek the help of both like an immigration attorney and whatever other attorney that handles your situation. Thank you everyone for joining me today. And I wish you all the best. Keep in mind, if you're interested in applying for something like a B2 extension I mentioned a few times, really you have to change to a B2 if there is a risk of you being out of status. Please do not continue to take those kinds of risks, okay? Then let us know if any of the other options that I mentioned to you are relevant to you. Feel free to contact us. Zell has posted my contact information in the chat, and all of you have received emails for today's appointment as well. You can reach out to us one of two ways, either from this information here, or reach out to Zell via the email that was sent to you confirming today's appointment. And I hope I've answered some of your questions. And you have a wonderful Friday and the weekend, and hope everyone stays healthy.